in all of this, most folks are familiar that I'm trying to remember the year 21 or 22, 400 from Missouri, go to south central Wyoming in an area called the Elk Mountain area, which is part of the historic checkerboard that was one of the railroad grants.
And it's just absolutely gorgeous area too.
Yeah.
To make clear, it is just outstandingly beautiful.
Yeah.
As well as being part of the checkerboard.
Yeah. And we'll get into the fact pattern, because fact patterns, you attorneys always say, are extremely important.
Yes.
They bring a ladder, they cross at a corner, and hopefully the audience understands what checkerboard means and what corner crossing means. It's like when checkers, you got to stay on black. So you go diagonally from black to black to black, or red to red to red. Here, you're trying to go from yellow, which is BLM, to yellow to yellow to yellow amongst all the white pieces, which are private.
Exactly.
So they end up in court, in Wyoming court, state court.
Yeah, exactly, for the criminal charge first.
Right.
Yep.
So they get cleared of the criminal charge.
Acquitted. Yep.
Yep.
Which, and again, just to be very clear there, that doesn't mean that they couldn't bring criminal charges in the at that point. It wasn't clear that you couldn't bring criminal charges in the future. Just meant that the jury, based on the facts in that case, decided that they were not guilty of a criminal trespass.
Right.
Yep.
So in prior podcasts, I've had other attorneys on, Nick and Tom. They've been on twice. They were the ones who they started advising me on this stuff before I knew about the case.
Yeah.
Because I was trying to learn more.
Yeah.
And then the case comes out. I'm like, guys, you're not going to believe this. But the hypothetical we've been talking about is a case in Wyoming.
Yeah.
Anyhow, so when Tom and Nick have been on the podcast, they've talked about the distinction between criminal trespass and civil trespass.
Which a lot of the Western states have, including Montana, I believe.
Right. Yep. And since you are licensed in Colorado, which is a 10th Circuit state, and you're also licensed in California, which is a 9th Circuit state.
And licensed in the 9th Circuit technically as well.
Okay.
Yeah.
So for people who maybe didn't listen to those podcasts, I'm going to summarize in a layman's term, and you're going to correct me, I'm sure. Criminal trespass is, state law says, here's our criminal code. It's statutes. You violate this, the sheriff's going to come, and you're going to jail, or you're going to get arrested, or
pay a fine,
whatever it might be. Then there's a completely different part of law that is our civil code, if you want to call it that. I know it's a code. It's
in most states it is a code.
Okay.
Yeah, not to get into it. Louisiana follows the French system where it's a little bit different.
Okay, so you can be acquitted of a criminal action, but yet that doesn't prohibit a private party from bringing a civil claim against you. And the example I always give to people, and a lot of people, I age myself by saying this.
You're going to use the same one I think I use.
O.J. Simpson.
O.J. Simpson.
Yeah.
That's exactly the one I use.
Okay.
Yep.
O.J. Simpson.
It's the best one.
Johnny Cochran and F. Lee Bailey get him off the hook for the criminal charges of murder, whatever it was.
Yep, he was acquitted.
Yeah. But then the family, the Goldstein family, sues him under civil actions.
Yep.
And they win.
Yep. Basically for the same thing. It was suing for unlawful death. So it's basically the same thing. The major difference in criminal and civil is criminal you need to prove beyond the preponderance of doubt, which means basically they don't tell you what percentage that is, but it's a lot. Where, I mean, I shouldn't say that was wrong. You have to prove it beyond any reasonable doubt.
Right.
For civil, it's preponderance of the evidence, which is 51%.
Right.
And that's why there's always a major difference between the two.
Right. And so the other difference is a criminal case, you're usually going to have some body, a governmental body is likely who is pursuing the charge.
They have to. Yep.
So that's why you might end up in court and you're fighting with a district attorney or
prosecutor,
a prosecutor or whoever. In a civil case, The sheriff and the county attorney and the prosecutor aren't who you're fighting against. Your attorneys are fighting against the attorneys of the plaintiff who brought the claim and made you the defendant.
Yep.
So, just so people understand that, because that's a unique thing that happened in this case. So along comes Iron Bar Holdings. Is that?
I think that's right. I have iron. We always call it Iron Bar. Yep. But yeah, I
and
think
a lot
it is
of
Iron Bar
people
Holdings.
want to use the name. It's the landowner or the guy who owns Iron Bar Holding as a person from North Carolina.
I was going to say, I think he's a pharmaceutical executive from North Carolina,
Yeah.
but I don't want to be, I don't know exactly for sure, but something like that.
Doesn't matter.
Nope, not at all.
The group making the claim is his LLC.
Yep.
That says, you have violated my rights and you have created damages of this amount.
Yep.
We're going to court.
Yeah.
So now the 4 hunters from Wyoming who thought, wow, I got off the hook. I didn't get a citation. I'm not going to get a fine. Get a letter, a subpoena saying, hope you got a lot of money because we're here to get it from you.
Yeah.
We're going to sue you for this.
I think they sued for like $7 million or something like that.
Yeah.
So pretty much worse than the criminal charge.
Yeah.
They were. I guarantee the fine wasn't going to be $7 million if they were found guilty there.
Yeah.
So
that goes there to the. I'm trying to remember. That claim was filed where?
The state court in Wyoming.
Right.
I can't exactly say which state court, but let's just say state court in Wyoming. And basically what happened then is that the Wyoming hunter, and again, these hunters are not from Wyoming, but the hunters in Wyoming then what's called removed the case to federal court.
Right.
And the way that you can do that is when this is getting a little bit in the weeds, but it's called diversity. So if you have if on one side of the lawsuit is a citizen from one state and the other side of the lawsuit is citizen or citizens from another state, and the amount in controversy, aka what they're suing over, is over $75,000, you then have the right to remove it to federal court. And that's what happened here, because the hunters were also from the South, but again, they were in a different state than the LLC. And again, not to get in details, but the owner of the LLC.
Right.
Yep.
So their attorneys got it removed
Federal
to
district
federal
court.
court. So in federal court, the 4 hunters prevail again.
Yes, at summary judgment stage.
Yeah. Well, the LLC and its owner says, I still don't like that outcome. 10th Circuit, here we come.
Yep.
So tell me in the audience how a case, because you clerk doing this in the 9th Circuit.
Yeah.
How does a case, do they have the right to say, oh, we're not going to hear that? Or do they have to hear it?
Yeah. So basically the best way to understand the federal court system in the United States is a system of 3 separate courts going up and going up. So at the bottom level, you have the federal district courts, which are basically easiest explained as trial courts. Every state at least has 1 district, and some states have more than 1 district. And then at that point, if you don't like how the outcome in that case came, you can then appeal to the appeals courts. And I'm going to get this wrong, but I think there's 13 appeals courts in the United States. There are 11 that cover various states, and then you have the D.C. Circuit, and then the federal circuit, which covers very specific claims. Okay. So in this case, Wyoming is in the 10th Circuit, so they appeal to the 10th Circuit, and they have the right to do so. And then your final option is to appeal to the Supreme Court, which is when we get into most of the time, the Supreme Court has has discretion to choose its caseload. And then, again, not to get in the weeds, there are some discussions on what is discretionary and what's not discretionary, but for this purposes, this case would be part of their discretionary caseload. So Iron Bar Holdings had the right to appeal to the 10th Circuit, and they exercised that right.
So they go to the 10th Circuit. We sit on our kind of keyboards waiting to see what the outcome is.
Pins and needles for over a year, I think.
Yeah. And that case came out this winter.
It came out in March, if I'm not mistaken.
Yeah. So the court ruled, issued a lengthy opinion, gave its rationale for why they decided, made a few statements of facts and other things, and the hunters prevailed again.
Yeah, they upheld and affirmed the district court. However, as we'll probably get into, the reasoning was, I wouldn't say drastically different, but significantly more broad than the district court's ruling, which is actually, I think, the most interesting part about this case.
Yeah. So that all happens. The plaintiff again has until June 16th.
At that point, they had until June 16th. Yes,
to
sir.
tell or to ask.
To file, it's called file a petition of cert, and I'm going to mess up my Latin because I am definitely not Latin. Petition of certiorari. So that basically just means you're telling the Supreme Court, hey, I want to appeal this case, and you're giving the Supreme Court your reasons of why you want to appeal the appeals court decision.
Okay.
Yep.
So they have until June 16th. They file a 30-day request or a request for a 30-day extension
In May. Yep. And just so everyone's clear, these extensions are routinely granted. So the grant of this extension bears absolutely no weight in whether the Supreme Court will take the case or not.
Right.
These extensions are, I wouldn't say, let's just say almost always granted.
Yeah. So if the extension's granted, everybody has to buckle down and get their work done. And then we're going to be in a wait and see mode again because there's no mandatory requirement that the U.S. Supreme Court takes this case.
We are in a wait and see mode. However, since we have so much data on the Supreme Court, we have a general idea of how things work. Mm-hmm. So basically what happens is Iron Bar is going to file their petition for cert on July 16th because that's when it got extended. The respondents, the hunters, are able to reply to that within 30 days. However, they can also ask for an extension.
Okay.
But again, to be very clear here, when they ask for an extension, it is only 30 days. You can't. It's kind of like, the best way I describe it is like when you're working as a lawyer in front of court, it's kind of going to school. You have these deadlines and you have to get your work done. But unlike school, you can always ask for an extension, but you generally don't get more than one extension unless you have some really extreme circumstances. So the respondents will be able to respond by August 15th, I believe is what I had down. And then at that point, that's where stuff starts to get interesting. Okay. So we have Wyoming that might want to weigh in, and that might extend how long it goes. We also might have what's called a reply brief. So this is when Iron Bar would reply to the hunters trying to argue that that Supreme Court shouldn't take the case. Again, unlikely. Wyoming is likely. At that point, the whole case would be briefed around end of August, roughly. And that's if there's no extensions. If there's extensions, we're looking at September. Okay. What that means is we are pushing when the court may take the case all the way into 2026.
Right.
But here's the other thing, the other really interesting wrinkle. This is what we have, what we call, again, like I was talking earlier, a preemption case. So we have a federal law that is preempting or overruling a state law. And in this case, the federal government won. So what is probably going to happen is this is going to be our key of whether the Supreme Court's going to take the case or not.
Okay.
In August or September, the court is either, this is all most likely, they're going to what's called schedule the case for conference. So the case is distributed to the justices in a conference. After that conference, the justices will likely deny the case. They will ask for the opinions of the Solicitor General of the United States, or they will what's called relist it for a later conference. So if they deny the case, the 10th Circuit ruling stands.
Okay.
And the Supreme Court doesn't give any ruling. If they ask for the opinions of the Solicitor General, then what happens is the Solicitor General will file a brief either supporting the 10th Circuit ruling or saying, hey, the 10th Circuit got it wrong. This federal law does not preempt corner crossing, state trespass, that sort of thing. And he will generally file that brief in January. And then in January. And then if they relist it, that is a good sign for Iron Bar that they're going to take the case. But again, we don't expect them to relist it without hearing from the SG. So now we're in January, right? Again, assuming that it wasn't denied. The SG files his brief, and at that point, the Supreme Court will either deny the brief or grant the brief, deny the petition for certiorari or grant the petition for certiorari, and we'll find out about that January, February. And the interesting part about that is that's really at the end of their term. So they could put it into, and now we're talking about 2026, but they also could push it to the next term, where it's the end of 2026, beginning of 2027.
Right.
So the way I've been kind of telling people is we're either going to probably find out that they're going to deny the case at the end of, deny the petition for certiorari at the end of this year, or we're going to find out that they grant the petition of certiorari early next year.
Okay.
That's kind of the timeline. But like most things in the legal world, it is way more convoluted than it absolutely needs to be. If we just followed school rules and we got everyone to file their briefs on time, we would be all good and dandy. But lawyers as a breed are chronic procrastinators, and I can guarantee I'm one.
Okay. So what is relevant and important at this point, and what then becomes speculation at this point? Speculation is what the Supreme Court would do, what other circuits would do.
Yep.
But we do know what happened and where we're at with everything related to this case right now. So in my disclaimer, I told Dylan that if he came on this podcast, there would be a disclaimer that nothing he says is legal advice.
Yep, nothing is legal advice whatsoever, and especially since I am not admitted to the state of Montana or any other state, basically, other than Colorado and California, and I am not anyone's lawyer. I am trying to just give some friendly advice
to me.
To exactly, give friendly advice.
For the purpose of having a discussion.
Exactly.
Right. So we're not going to read it really fast, like when you hear these legal disclaimers on Sirius XM.
Yeah.
I always think that maybe something's wrong with my radio.
Yeah.
I'm going to say it real slow. To all of you listening or watching, nothing you hear on this podcast can be, should be, or will be construed as legal advice that you should rely upon.
Or that I'm anyone's lawyer.
There you go.